you pleaded guilty to, I think it was just paragraph 1 of this indictment, right?
That's correct, Your Honor.
Which was third-degree felony, charging you with causing bodily injury to a disabled individual. And a pre-sentence report has been prepared in this case. Have the parties had an opportunity to review it? And are there any corrections or changes to it, beginning with the state
No, Your Honor.
and defense?
No, Your Honor.
Then it is made part of the record for all purposes. All right, the agreement is whatever sentence shall not exceed a cap of 6 years imprisonment. So I think what we have here is several options. The defendant could be placed on deferred or unadjudicated probation for up to 10 years in length of probation. He could be found guilty, sentenced to no less than 2, no more than 6 years confinement in prison, and that could be suspended and he could be placed on probation. And finally, he could be sentenced to no less than 2, no more than 6 years confinement in prison. Those are about every option available in the Code of Criminal Procedure and the Penal Code. So is the defense ready?
Yes, Your Honor.
Go ahead.
Your Honor, with this particular case, what it really stems from, and I know you've read the police version of it, but let me give you a little bit more into that.
Mm-hmm.
This is his biological daughter. They've been having problems with her posting naked, nude images online. So that's a problem that he's been having with his biological daughter. And they've done things to address that, counseling, talking with her, working with her over and over and over again. Well, on this particular night in question, his current paramour, and she's to my right, and she has a hand up in the courtroom. As you can see, that lady is disabled. She's in a wheelchair, and my client is taking care of her. He's her support. He's everything. The biological daughter got mad at her for for disciplining that was taking place and actually hit her. Now, Judge, I remember a time, and I'm quite sure you do as well, when a child typically would not raise their hand to an adult. And I'm not justifying my client's actions, but, you know, when the child with a history, with the promiscuity that was going on, and then the child assaults a disabled lady, my client did take her into I believe the adjoining room and discipline the child by spanking. Now, I'm not saying that the extent of the spanking was justified, because I'm quite sure many of us in this courtroom have been spanked. I mean, I remember myself when I was in high school, it was common for the coaches, assistant principals to give corporal punishment. And I'm quite sure even when you was in school, Judge, you dealt with corporal punishment to an extent. So I'm not saying that, you know, the extent of the corporal punishment was justified, but the circumstances.
Well, what wasn't justified that you think?
The lashes and the butt, the thing went too far. I mean, I know I've got corporal, and I'm quite sure you have too, but I haven't been hit like that. And
so you're saying something was wrong with that?
Yeah, no doubt about it. I'm not defending that. I'm saying something was wrong with that. Mm-hmm. But what I'm saying is
what was the defendant striking the little girl with?
I think it was a fishing rod.
A fishing rod.
Right. I think it was, and don't get me wrong, Judge. I mean, okay. I know in my day when the coach got us, it was a
fiberglass rod.
No, it was a powder. I got it, and
I'm quite sure you got a fiberglass rod here in this case.
Right. Absolutely right. Right. But I'm saying,
anybody want that? Anybody want to get struck by a fiberglass rod?
No, not at all. Not at all.
I'm not asking who would want to strike Rife, because everybody's hands would be raised. all the defense bar is raising their hand.
But I'm quite
talking
sure-
about something else.
But I'm quite sure he
But
got a paddle when
The
he went to
point
school.
being is there's some disturbing facts. here.
Absolutely. And I want to deal with those, Judge. You
How old is the
absolutely
child?
right.
Was the child?
This is a teenage girl, right?
How old was the child at the time of this event?
17 now.
She was 16, Your Honor.
Okay.
Yeah. So, Judge, like I say, I mean, I'm not defending the extent of it. I'm just saying the circumstances in which he lost a little bit of control.
Are there any photographs of the injuries?
There are, Your Honor. On a USB drive.
This states that she had lacerations and cuts on her back and upper right shoulder.
She was also missing a fingernail.
Say that again?
She was missing a fingernail.
Oh, well, I thought you said just finger. Fingernail? Did she lost a fingernail in this?
Now, my client is gonna say that had nothing. This fingernail had nothing to do with him. That's a separate. That had nothing to do with the spanking.
That's the least of my
Right.
concerns on this. Yeah.
Right.
Whether let's put the fingernail out.
Right.
Let's just take that out of the equation.
Right. And
It's still disturbing.
no, it's no doubt about it.
Okay.
And where I'm going with this, Judge, is again, is that corporal punishment should not go to that extent. The only reason I just brought it up is that many of us in this courtroom have had corporal punishment. But what I was trying to say, Judge, is the circumstances of this is the little girl hit an adult, and the little girl had been posting nude pictures of herself. And the parent is reacting to that. And the extent that the parent reacted was a little bit, well, not a little, it was too far.
Okay.
So with that being the case, our argument for asking you to put him on deferred adjudication is a two-fold argument. The first argument, and I had Mrs. Whitmore as yeah, I'm sorry, Whitmere as a
Whitware.
witness.
W.
Yes, as a witness, and she wanted to talk to you directly. I know she's in a wheelchair; she's not be wheeled up. But what she's asking you for is this: is just to have sympathy for her particularly. That's the caregiver. She's in a wheelchair. The only reason she's in court today is because he drove her here. I mean, if he was to be put in jail today, she doesn't even have a ride home. I mean, he's taking care of groceries, taking care of this, taking care of that, and she wants to talk to you directly.
So what's the point?
The point is that she's going to beg you to put him on probation and to have mercy on him, and that would be the point of her. So, and she wants to talk to you directly.
Okay. Well, but you're saying he needs to be put on probation so he can take care of her?
That's one. That is one. That's
Is that an important reason?
well for a lady that is not mobile. Yes, for her it's super important because she can't get around.
Okay. And do you feel as though that's necessary here in this circumstance?
Well, in this particular circumstance, why I was asking, in addition to that, is that he went too far in disciplining his child. But will he be?
We're talking about. I mean, the grand jury indicted, and
Right.
and apparently the defense is admitting liability here and
Mhm.
culpability. The question is, what do we do, and what message do we send out?
And what I would suggest that you do is put him on the intensive supervision program, get him the anger management, order that he takes parenting classes, order that he takes the battery intervention classes, order him to take classes that help him to cope better with those circumstances. But at the end of the day, I think that this was a situation where he went over the edge because the little girl hit the disabled lady, and the little girl was posting naked pictures online. And I think as the father, he overreacted. I mean, that's the only way I can describe it. He overreacted in the discipline of her. Now, I'm not saying corporal punishment is bad. I got corporal punishment when I was young, and I'm quite sure you got it too. But at the
Never did, but I can understand how you would get it regularly.
well, you probably got it at school.
No, we all. I think we all.
Yeah. So
Should. Everybody makes mistakes,
true.
and
And
especially children have to learn from mistakes. And
right.
but how you deal with it. I never had a fishing rod
No.
slapped on me.
And I have
my back and my buttocks. I've never had that. That's it's a deadly weapon because in the manner of its use, it can cause serious bodily injury.
That is correct, Judge. And that's why I'm not defending the parent.
That's a problem. That's the issue. That's the aggravating factor here.
Absolutely. And to address that, what he's telling me now is that I believe, in your bond orders, you have no contact with the victim. That's typically what you do.
Yeah.
When I talked to him before, he's telling me, now I'm only going to know what he's telling. He's telling me that he's not having contact with the girl. And with her being 17 years old and she's fitting to be an adult, at least according to what Ms.
Where she lives?
You know where she lives. I don't know.
The grandmother.
Somewhere else.
She's with her grandmother.
She lives with the grandmother. So there's not going to be a danger to the child because he's not around her. And in one more year, she's going to be an adult, 18, doing whatever.
He's not a danger. He's not a danger to the child unless he gets around. That's the statement. I mean, I can order this. I can order this, but
and he didn't defy your order by going around her, at least to my knowledge, and talking to him. And that's why I was asking, Judge, that if he gets that treatment, and I know your probation is high success, he's going to be successful on that probation. He's not a danger to the child. And this was just a parent that just went over the edge with his little girl that was posting naked pictures online, and the little girl who hit a disabled person. The discipline went it went too far, but to put him in jail for 6 years, I don't think is the solution to this. I think the solution is to get him the help with the classes, the treatments, the battle program, the anger management program, conflict resolution program, have him check in with you. And that's part of one of the reasons, I had talked to him about, and he wanted to do this cap because he knew that the cap would be totally in your hands. And I said, hey, talk to Judge Stevens, talk to him yourself, and he would be open. I can't tell you what he's going to do, but he'll be open to what you got to say. So I'll leave it with him, and she just wanted, and if you don't mind, Judge, she's in a wheelchair. Do you mind if she just says one word from there?
what is she going to say? Yeah, we can't control outbursts, but what is she going to say?
I anticipate that she's going to beg you to allow him to have probation.
Is that right?
Yes.
Okay. That's conveyed to me.
That's what I anticipate
understand
that she's going to say.
Okay.
And then as far as him, I don't want to put any words into his mouth. I let him speak to you directly. Oh,
Let me ask, hold on. The defendant was convicted in 2014 of burglary of a home.
that's true.
What was the sentence?
4 years TDC.
What other criminal history does the defendant have?
He has quite a lengthy misdemeanor history, Your Honor, of possession and theft. And then he's got an unauthorized use of a motor vehicle that he got 1 year state jail for, the burglary of a habitation that he got 4 years for, the aggravated assault with a deadly weapon that he pled to a lesser and got 180 days state jail, and then the new injury to a child disabled.
Okay. So this is his fourth felony offense?
Yes, Your Honor.
Absolutely.
Fourth felony conviction or not. It's fourth felony case that he's subject to sentencing on. Okay. And this goes back over for 30 years.
Mhm.
Misdemeanor is a 96 case.
Mhm.
And it doesn't go without notice that in 2018, it looks like he did 90 days in the county jail for assault of another person. So this isn't his first assault either.
No, he also had the aggravated assault in 2018.
It's his third assault.
And Judge, I'm not hiding from his past. His past speaks for itself. It's just in this particular incident, and I know his past, you can't learn from. His past is what it is. You got a little girl that's
It's never in the past.
No,
It's
the current.
What the famous written saying is.
Right. And like I said, I'm not justifying his actions. I'm not trying to say that it was right. But what I am trying to say is you got your daughter posting pictures of herself online, and then that daughter strikes the stepmama, he overreacted to that.
Yeah, I wouldn't have gotten a deadly weapon and
No,
assaulted the child.
Yeah, I agree with you on
Okay.
that. You're right. But that was the circumstances.
No, that's why we're here.
Right. Right. And that's why I was asking you to consider him for probation. It's those particular circumstances of this particular case. This is not one of those cases, because I do CPS cases too. I mean, it's not one of those cases where you got the parent who, for example, got the cigarette and torturing that child, or the parent that's not feeding the child. In this situation, you got the parent that was disciplining the child after the child had struck a disabled woman, and after the child was posting naked pictures online. And I think he went too far.
But it's the legislature cites it as a third-degree felony. It's not the least serious type of felony either.
Yes, you absolutely
Third-degree
right.
felony where you can go up to 10 years in prison, according to the legislature. So it is set forth in the law how important it is and where it places. And the elements is because a child was one. And in this case, what's lucky is that I guess that a deadly weapon wasn't alleged in here. I don't know what difference that would really make, since being a child makes a aggravated crime. But well, it would have been aggravated assault. It's a different type of crime. Aggravated assault with using a deadly weapon could have easily been alleged, and it's a second-degree felony, more serious. But you can't harm a child in this way. Then children should be disciplined. That's how way they learn and correct behavior. Nobody's debating that. Just you just don't use a deadly weapon in with the device as the instrument to discipline someone. What state saying?
Your Honor, the defense has really failed to mention what I think is a key part of this case, which is that the child has intellectual disabilities. Just because the child...
Tell me exactly in this case what we're talking about.
The child suffers from... She is mentally slow. She had a hard time talking to police. This is why it's a third-degree felony, was because of her intellectual
Does she go to a
disabilities.
special program in school? Does she attend a special program? Or
It was supposed to be. I don't know if she is now.
what about that, Langston? Do you know anything about that?
With your daughter, because he know better than me. Are you aware about any kind of intellectual? Because they're saying that she you address that. You can address that yourself. I mean, it's your kid. You know better than me.
With my daughter, I got her like February 22nd or February 28th of 2022. My daughter was
Say that again.
He said February
22nd or February 28th.
Of 2022.
The
What do you
2000.
mean you got your daughter?
You got
I got my daughter back.
He didn't have custody.
I never lost my rights, but she was in foster care. She was staying with a lady named Miss Ella Davis. She got put into foster care because she ended up on the second floor by herself at the age of 1 or 2. And I never.
Why is she in foster care?
She's not in foster care now.
Why was she in foster care?
Because her mother, she's a drug addict. She left her daughter with her mother, which her mother passed. She left my daughter with her mother, her grandmother, and my daughter ended up on second floor. And the neighbor, I found this out when I was working. The neighbor called, and they ended up taking my daughter into the CPS custody. But the lady didn't want to separate her from her brother and her sister. So she was with this lady for so long, since she was 1 and 2 years old. She was with this lady up until the age of 14. I didn't get my daughter to after that because my daughter, she did something to the lady. She cursed the lady out. She wilded out with the lady. So the lady sent it to her mother. but her mother was not supposed to have her because she don't have no rights over her. So I ended up getting her at that age of 2000. At the age of 14, I ended up getting her then. But when she was with the lady named is Ella Davis, she never told me that my daughter was like this. I never knew it myself. I thought she was just, normal. I never knew she had this problem or that problem or anything like that. I never knew none of that.
How old are you right now?
I'm 40. I just turned 47.
Go ahead.
So, and don't get me wrong, when she was in this foster care with this lady, I was making it my duty to take the time out of my day when I was working to go spend time, check on her or getting to know her or whatever, because every person in school told her they told her she didn't have no daddy. So that kind of broke her a little bit, but as me showing in my physical form, by me showing my face, by me letting her know that you got a daddy that loves you, you got a father that's gonna be there for you. But all this other stuff that's going on, I never knew none of it at all. Ain't nobody never told me that. They kept me in the blind. So I had to go off of what I know, and by learning her when she was with me, that's the only way I learned her.
So in summation, what you're saying is that if the state is suggesting that the child had some type of a mental issue or delayed issue as far as mind, whatever, and that was documented, that's something that you did not know about. So you responded.
I have no recollection.
You had no information about that. Is that right?
Yes, I have no recollection of it. I thought she was okay. I have no information on anything but her just being my daughter. That's the only thing I knew. And by me putting her in a government federal program, but she did the pornography on a federal government program. So the school called me and told me I need to check her computer.
Right.
I need to do this, or I'm gonna have federal charges on me. I can go to federal prison for what she did. I didn't understand it. My daughter did this for age 14, 15, and 16.
Right, but your response to the state's question that was brought out is that if there's any documents that go to mental issues or whatever, you weren't aware of that.
I wasn't aware at all.
Anything else?
No, well, that's all I got, Judge. And like I say, he and his spouse that's here is basically begging for mercy from the court. And basically, you had a father who overreacted when the child punched her, and when the child was putting those naked photos online. And it was an overreaction. It shouldn't have taken. Shouldn't have hit her with the rod. The injuries to her back should not have occurred. Many people get caught, like I have, like you, and many people caught, but none of us got anything like that. And I know I've never got hit like that in my life. I've never had where I was bleeding. Never, it's not anything like that happened. But what I am saying for mitigation purposes is that he just overreacted as a dad. I mean, he went too far considering the circumstances in disciplining his child. And there's nothing that the state is saying to refute that this was about disciplining the child.
If I could, Your Honor, I can refute that. I just haven't had a chance to speak.
You'll get a chance. Anything else you want to know?
That's all I want to say.
Okay. By the way, the pre-sentence report had been tendered. Were there any corrections or changes to it?
No, yeah.
Other than that, then it's made a part of the record for all purposes for this sentencing. Okay, stay.
Your Honor, I would like to point out what the victim said about this case to police when she ran to a restaurant to ask for help because her father had beaten her 30 times with a fishing rod, is that They had believed that she had stolen some popcorn from a corner store, not that she had assaulted her stepmother or that she had done anything with any pornographic videos, but that she had made popcorn and that he had saw a juice box in her room, and that's what caused him to beat her. When officers responded to the medical center, they estimated that he hit her 30 different times with that fishing rod. This was not corporal punishment. This was abuse. This was torture. And then in his statement to probation, he said, "I'm upset and disappointed from what my daughter has put me through." Not any remorse for anything that he did to his own child, his own disabled child. He wants to have probation to help another disabled person when this is his fourth assault case and it's his fourth felony offense. I see no reason why we wouldn't give him any less than 6 years confinement.
Anything, any summary you want to make?
Well,
Or response? You have
what a quick response is that we said it was discipline for assaulting a disabled person. The state said it was discipline for something with the food or what have you. But at the end of the day, this was discipline, and she can testify if you want her to that she was hit. She's in the courtroom. If there's any doubt that this child hit an adult, the person that was hit in the courtroom, I said, Judge, you can ask her right now. She's here. She'll tell you she was hit. I mean, you're looking at her. So, I mean, she's available. There's no doubt that this child punched an adult disabled lady who's in the courtroom. And like I said, he overreacted. He shouldn't have gone to the point that he went to, but this was about disciplining this child for the pornography and for the assault. And that's why we asking the judge. I don't think that he's going to leave this courtroom and be a danger to anybody, go break the laws or go do anything like that. He just want to take care of his wife, who he drove up here today. And matter of fact, if he went to jail this very second, I don't even know how she would even get home. I mean, I don't know. I mean, I don't even know how she would even get home. He's been doing a good job with taking care of her. And I told him, I said, hey, I don't know what's going to happen. It's a cap of 6 years. The judge will give you deferred. He can put you in jail for 6 years. He can give you 2 years, 3. I told him, I said, I don't know. I say, but at least one thing for certain, whatever it is, Judge Stevens is going to be fair. Talk to him and just make your case to him. And I'll close with him. Is there anything you want to tell Judge Stevens that I left out?
Before things seem to be right, this is I don't want to be there for her because she needs me regardless, you know. I'm the only one that's there to do what I need to do for her. I'm not too much worried about me. It's just her. I gotta get her out the bed, help her out the bed, help her in the shower. I got to do all that. And she can't, it's hard. She done failed over 5 times. 5. Because she been through so much with the person she used to be with before. And it really made it bad for her. She's wired up on her right side. It's hard for her to walk. I got to cook. I wash clothes. She don't do nothing. I do everything that's possible that I need to do for her.
All right, I'm going to ask you just a couple of questions. How many misdemeanor convictions do you have? I mean, it's your life. No one would know better than you.
Three, four, I'm not sure.
3 or
it's been
4,
so long.
you think?
It's been so long. I don't keep up with it.
It was as recent as 2018. But you were 3 or 4?
Yeah, I think it's 3 or 4. I'm not
10. 10. There are 10 of them. And let's see. most of them drug offenses, and then there's assault causing bodily injury was the last. What about felony offenses? How many felony convictions do you have? See how close you are to the correct answer, guessing your life's history.
Possession, weapon, burglary, habitation.
What does that say that you don't even know the answer? What does that say about you? I tell you how many I have. I mean, that would be an impact in me because that should be a major part of your life. But
Then we got about 4 judges.
I have 3 and then this one. So 3 convictions. But the point is that that's 13 convictions in courts of law, non-Class C misdemeanors and courts of record. But that's far too many for anyone. But there's so many you can't even remember. And in this case, the defense, you don't give a lot for your attorney to help you on in these circumstances because nobody finds injuries to a child amusing, much less appropriate. It's completely and totally uncalled for. Yes, they need to be disciplined, but you don't take a deadly weapon like a fiberglass fishing rod and beat the child with who ended up with, let's see, multiple welts, obvious welts on her back, both arms, backside of her legs, bleeding, swelling, and redness of her injuries. Nobody feels sorry for you. Nobody feels sorry for you. And you've said in your whole set of defense and statements here, the motivation was her actions, her actions. The pre-sentence report that's in evidence, you're 45 years old, 44?
47.
Yeah. You were a daily synthetic marijuana user for over a decade until just a few years ago, according to you. Synthetic marijuana makes anybody out of their mind. So that's the role modeling that child had to deal with from you. Multiple years of synthetic marijuana, cocaine, weekly cocaine use for 8 years until you were 30. You admitted using LSD, ecstasy, marijuana, monthly since you were 18 years old until a month ago, according to the pre-sentence report. Diagnosed with depression, symptoms of anxiety, attempted suicide. You participated in patient treatment for mental issues at Ben Tom. What kind of role modeling is that for the poor child? I have children, and they're going to emulate what their parents' examples are. At the very least, you get poor parenting of the year. You're a terrible parent. And so it's the child's fault that she wasn't acting appropriate. And so you beat her. You've got to see how bizarre that is and how missed of the mark you are. You've got it backwards. You're responsible.
Yes.
Not I feel sorry for the child. The child really didn't have much of a chance because role modeling is the most important influence on a child from the parents. Yeah, and now you're saying you want to do something that is humane for the lady that you're taking care of, you're living with, and that's your get out of jail free card. You can assault a child after all these years and years of abuse to yourself as well as to the child. And then you want to be able to say, I got to get out of jail free card. I got to take care of somebody. Now you are practicing humanitarianism. You hadn't done it to your own child. Your own child doesn't get it, your own blood. My goodness. Why would you be so worried about someone else? The creator gave you the child. You chose a partner, which is okay. But how did you do with what gift the creator gave to you? You abused the child and self-abused yourself with narcotics years and years and years and years and years, which didn't give the child any hope or role modeling opportunity to make wise choices. This all explained. All right. Yeah, you were in jail for 7 days here in this, according to this record, in accordance with this case. When you were in jail, who was taking care of the lady?
No, there was nobody there.
So she's able to take care of herself when you're in jail. Well, there she is, and you were in jail for 7 days. How did she survive?
My neighbor came and checked on her, but my neighbor works, so my neighbor was able to check on her or whatever. But when she needed somebody to check on her,
Okay.
so I had to have my neighbor to check on her.
If nothing further, the court's going to find the defendant has pleaded guilty here to this third-degree felony of injury to a child. Voluntarily, knowingly, intelligently, there was sufficient evidence supporting the guilty plea to find you guilty beyond a reason, based upon State's Exhibit 1 that was introduced into evidence. I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That is one of the options that the court has. I want that just to sink in for just a moment. So you go prison for 6 years. Your paramour, the lady you're taking care of, she's stuck without anybody to take care of. The child, father's in prison again. And then all you're doing is making a mess. Another chapter in the same book of here I am making a mess. The court's going to do this. Okay, I'm going to suspend the 6 years, place you on probation for 10 years. There will be terms and conditions of probation that you sorely need for dealing with other humans, as well as your family that you seem to disrespect and not have a humane attention in dealing with. Here's the regular probation orders. There needs to be some kind of program that moral recognition therapy, some comes into mind. Parenting class comes to mind, which you've wisely, the probation has already offered to place in here. Mental health services through Spindletop, enter in successfully completing the battering intervention and prevention program. You're going to submit to a substance abuse assessment because it's hard to believe anyone with years and years and years of chronic abuse to drugs telling us the truth and being forthright. Seldom does that ever happen. And there will be other terms and conditions of probation which you need to follow which ironically are in your best interest and to help you be a better person. Why you haven't done this yourself. And you had to come into this court as a defendant assaulting your child, for strangers to have to fix the mess in your life is inexcusable. But it happens all the time in here. That's what we do. That's not all. That's not all. When you harm a child, it goes with a price. You're going to serve 180 days in the county jail, and we'll do that on weekends. You're going to have to work some way to have this lady taken care of. But you don't avoid responsibility and punishment that's due by using the helplessness of others. Like, no, she didn't have anybody to take care of. You got to figure that somebody's got to help her. For those, you report on her before 6:00 p.m. each Friday. Release you on 6:00 on Sunday, and you'll do that until 180 days are served. Do you understand? That's the price that this court sets, because children should not be harmed, especially tortured. And then if you have the tendency that 180 days. All right. You understand what has happened today, sir? Yes. This is what is called justice. This court deems it to be the appropriate method, and it has its seriousness for the consequences and the circumstances of the harm to children and your self-harm that you have performed on yourself by not respecting yourself, by abusing drugs and committing so many offenses. You need to fix all of that while you're still alive. Anything else?
I don't have anything. I have something, Your Honor.
Yes,
When does the jail time begin?
it's Friday.
This Friday.
Mhm. So you've got 48 hours to figure out a care method for the lady for those 2 days. Do you understand? Anything else? Please see the probation officer.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.